We got major news in the Lil Durk case. Charges that were added just weeks before trial are now being thrown out of this trial, and a federal judge called out prosecutors in open court. Durk scored this big legal victory that changes everything about his upcoming case, and we're going to break down what it means and what could happen, all with former federal prosecutor Neama Rahmani. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, big news in the Lil Durk case. We've been following this one from the beginning. So the rapper just scored a major legal win ahead of his federal murder-for-hire trial, where he stands accused of orchestrating a hit against a rival rapper. Yet you can see there members of Lil Durk, also known as Durk Bank's team, addressing the media outside this Los Angeles courthouse. This is courtesy of Rolling Stone reporter Nancy Dillon. And we're going to have more on that and the fight that they're prepping for at his upcoming August trial in a little bit. But I just want to give you a little perspective on you, put this into context about why this is such a big deal. So Lil Durk has been essentially sitting in a jail cell for almost 2 years. His trial was supposed to start next month, and that is for the 2022 killing of Savia Robinson out in Los Angeles. Prosecutors allege that this was a murder-for-hire plot stemming from a feud with rapper Quando Rondo, and that Robinson was just in the wrong place at the wrong time. But then, what was it, less than 3 months before trial, the government drops a bomb, and what just happened exploded in their faces, essentially. Durk was handed a new superseding indictment with new charges. We're talking entirely separate allegations that stretched across state lines in years. They're talking alleged involvement in a shooting in Chicago, this attempted murder in Atlanta, I believe even this apparently or allegedly drug trafficking operation, so all these different things. And suddenly, this case wasn't just about one episode. It was no longer just about this Los Angeles incident. It was potentially going to be a trial that included a whole different set of alleged crimes that his lawyers argued the government could have brought from the beginning, that they're not playing fair. This is according to court filings that we reviewed. And Durk's legal team argued, look, they would have a choice to make. Either they were going to go to trial on all of this and risk needing to ask for more delays to prepare, or they could fight to separate the charges and move forward with the August trial purely based on the Robinson alleged killing, right? And what did they do? They chose to fight. They chose to sever it. They won.
So appreciate the thoroughness that took place in that courtroom today. And so I'll ask you that was in the courtroom and then have read the filings to rely on his Honor's questions today and the points that he made. And as you, but most importantly, as our innocent client, Durk Banks, and I emphasize, our innocent client, Durk Banks, is waiting. We are looking forward to the close of business today.
That was Durk Banks' attorney, Drew Findling, along with other members of his team, including, by the way, former Young Thug attorney Brian Steele. Anybody who followed that case knows him very well. Again, this is courtesy of Rolling Stone reporter Nancy Dillon. But this is where it gets interesting, because the judge didn't just hand them a big victory by separating the charges, and now he's not going to have to face this at his August case. He basically called the government out in court. And what he said, you got to imagine, just stopped the prosecutors in their tracks. We reviewed all the filings in this, the motion, the government's opposition. Yes, what the judge had to say in that courtroom, a lot of courtroom drama. All right, I got to say something real quick. Look, we cover a lot of different dangerous situations that are happening in the world here on Sidebar. One thing that I don't think people talk enough about is being part of a data breach. You, your loved ones, all that private information is constantly at risk of being leaked, which is why I want all of you to keep your data safe online. Here's how it works. Incogni tracks down all of those old posts and search sites that's exposing your information, and then they demand its removal. Look, I was shocked. Turns out databases had all my information, and within days, Incogni was taking them down. The setup is super simple. You just create an account. Incogni's going to do the rest, and their Unlimited Plans custom removals feature lets you submit specific links that their privacy experts will personally investigate and remove. They can't harm you if they can't find you. Use code SIDEBAR at the link below. Get a 60% discount off an annual plan. That's incogni.com/sidebar. Okay, so I want to bring in somebody who can actually make sense of all this. I love to see him. Neama Rahmani, former federal prosecutor, expert in this area. Good to see you, my friend. Thanks for taking the time.
Jesse, thanks for having me as always. This is a big case here in LA.
Are people talking about it?
They are. I mean, look, obviously in the music industry, you got Brian Steele joining the team. So I think it's going to get a lot of coverage and press. Obviously, federal court, no cameras, but a lot of folks here have been following it. Obviously, the local press and as well as the music industry. This is a big one.
Okay, so I'm happy to have your perspective on what is a very big development. Now, I want to get into this motion that started all of this. So Durk's lawyers, they filed a motion to separate the new charges from the Los Angeles trial. And their argument was pretty straightforward. They said, look, they had been preparing for this LA case, this LA trial for 21 months. They were ready for the August trial. And then less than, again, 3 months before this trial, the government drops this third superseding indictment with all these new allegations, these new charges, right? Racketeering. And here's what they wrote in the motion, quote, because the last minute addition of the Vicar counts imperils Mr. Banks' constitutionally guaranteed right to a speedy trial, this court should sever those counts from the Los Angeles counts and allow him the prompt trial he has consistently demanded. The government's delay in bringing additional charges and producing evidence in support of those charges is unjustifiable. Any further continuance would be of the government's sole creation and would warrant dismissal of the third superseding indictment. Now, Neama, what's your take on this? What is the defense actually saying here? Because the way I understand it is like, they have a right to put the prosecution's feet to the fire. Look, we think our client's innocent. We want to go to trial. Is it fair that the government could just throw these new charges, these new allegations at them, seemingly at the last minute, which would kind of conflict with his ability to go to trial? I mean, what do you think of it?
Look, I'm as pro-prosecution as they come, but I have to go with the defense on this one. And the judge apparently agreed. Look, he's been in custody for quite a while now. I think October 2024. The government obviously opposed bail, and the judge agreed with him. So the fact that you have a defendant in custody and you have a trial date next month, and you're going to supersede to add these allegations in another state involving another murder, I mean, it's a big problem. You're the defense. You don't have time to prepare. So you're sort of stuck in this situation where you have to ask for a continuance, right, to be able to prepare your defense to this whole additional set of facts and witnesses and allegations. Or you have to move forward with really one hand tied behind your back. So really superseding at this late hour is going to be a problem in any type of case, but especially a case like this where the additional charges are so serious, they involve out-of-state conduct and witnesses. So what the judge said, look, if you really want to do this, you're going to have a separate trial. You're going to have to do things in a timely manner. And I agree with the judge's decision here, Jesse.
I think one of the unique aspects of it is that the defense had pointed out that the government had already tried to introduce the Chicago episode, the Chicago alleged incident, earlier in this case. They had apparently filed a notice saying they wanted to use that as evidence of other bad acts. But in February, they withdrew it. They apparently told the court they were taking it off the table. The defense made the argument, look, the court relied on that withdrawal. They cited the judge's own words from a February hearing, quote, the severance motion certainly is not a trivial motion. However, obviously, it would have been considerably stronger had the Chicago evidence remained in the case. And then months later, they say the government tried to bring it back, not as evidence of other bad acts this time, but as direct evidence of a racketeering enterprise. So Neama, just again, walk us through this. Why was this so important for the prosecution? And we'll talk about their argument in a minute, but why do you think it was so important for the prosecution to introduce this evidence? And why does the defense make such a big deal about the government withdrawing the evidence and then bringing it back later?
So there's a couple ways you can get this type of evidence in, and you talked about it. You can obviously charge it, right, which was what the government was trying to do here. Or you can bring it in through prior bad acts evidence. And we've talked about it many times. Often you'll see it, for instance, in a sexual assault case, right? You have charged victims, and then you have these other victims who say that they too were sexually assaulted, but for different reasons, maybe the statute of limitations or other reasons, the government doesn't charge that conduct, but it can come in to show motive, a common plan or scheme, right? So they're saying that Lil Durk here operated this criminal enterprise and they would go after people in retaliation, right? So from the prosecution's perspective, it's great. The more victims you have, it dirties up a defendant. It doesn't matter if it's a sexual assault case or a murder for hire case like you have here. So there's a reason that the prosecution wants to present this type of evidence. But trials have to be fair. So when you're talking about 404B evidence and witnesses, the prosecution has to provide that type of notice to the defense. And the defense will usually, if they can, contest that evidence, and the judge has to rule, like, is this really on point? And really, when it comes to 404B evidence, and again, I'm talking about other cases, but appellate courts have been more hesitant recently. That's the reason the Weinstein first conviction was overturned on appeal. The New York Court of Appeal ruled that you shouldn't have brought all these other bad acts witnesses. So you have the government in the Lil Durk case providing this notice that we're going to present evidence of these other crimes in other states. Then they withdrew it, and then they supersede to charge it. So I think that's part of the problem there, right? They're going back and forth, and I think that's the reason the judge said, listen, you can't do this, especially a month before trial.
Right. It's too prejudicial. It's not fair. And I think it was interesting. So this is per reporting from Rolling Stone, who I think had the transcript of what happened in this hearing. And we're going to talk more about what the judge said. But U.S. District Court Judge Michael W. Fitzgerald, who handed Durk this win, said, quote, "You think you will have a better chance to win if the Chicago incident is tried with the Los Angeles murder. It's obvious. You treat that as a feature, and I treat that as a bug. I'm concerned it's going to be unfair. I'm here to make sure both sides have a fair trial." Seems like he has a point. I mean, it seems like the prosecution wanted to introduce all this evidence because it would make their case stronger. But at the same time, does that acknowledge potential weaknesses in the prosecution's murder for hire case, the Los Angeles allegations?
It does. And part of the challenge here is a case like this, you're relying a lot on cooperator testimony. That's tough if you're the prosecution. But no question, if you have two murders or attempted murders instead of one, that's going to be a stronger case. The jurors might disbelieve one, but not the other. And I got to give credit to Rolling Stone. You're right. It was Nancy Dillon, the reporter who was there, who was fantastic. I know her very well. She's on top of these cases. So, but I think, look, Judge Fitzgerald is right. We're in the Ninth Circuit here, one of the most liberal circuits in the country. He's thinking, listen, it's not just about getting a conviction, Jesse. It's about making sure that conviction withstands appeal. And you know this would be an automatic appellate issue if Lil Durk was convicted and the judge allowed the prosecution to supersede at the 11th hour.
Look, and the defense, they pointed out the timing of everything, right? The government filed this third superseding indictment on June 4th. I mentioned that this was less than 3 months before trial. They produced a massive amount of new discovery. The defense claimed in their argument, look, this discovery required a 1 terabyte hard drive. That's a lot of data to review in a short amount of time. They wrote, quote, "The defense is now in a position where it has to review, digest, investigate, and be prepared to rebut terabytes of new data just 2 months out from trial on a charge carrying a life sentence. It is untenable." I think about what the government's argument would be, right? Why did the government wait so long? How do they justify it? So the government's response, because they didn't take this lying down, they filed a 30-page opposition saying that the Los Angeles alleged murder and the Chicago killing, they were part of the same thing. They're part of the same alleged racketeering enterprise, that they were directly connected, that Durk's lawyers were exaggerating the burden of the new discovery. Here's what they wrote, quote, "Defendant Bank's sole basis for severance is that the joinder of the Vicar charges at the August 20th trial would imperil his speedy trial rights. That constitutional analysis is factually and legally unsupported." And they also pushed back on the idea that they had been sitting on these charges. They said the investigation was ongoing. We know that. I mean, look, investigations can evolve. And they said they seized 59 digital devices. They had to review terabytes of data. They pointed out that 2 co-defendants in the Chicago case had only pleaded guilty in April and May of 2026, which gave them new evidence to work with. Why are they wrong? Don't charges develop? Don't investigations develop? Doesn't new evidence come out? Why are they wrong here?
Well, look, obviously things change, but the reason they're certainly behind the 8 ball legally is the fact that they're the ones that control when someone's charged and arrested. They move for detention. And the fact that now you're really coming up on 2 years later to supersede, even if it's not the government's fault, it's not like they're getting sanctioned. you are prejudicing the defendant here, right? Because now you're putting them in a position, like I said earlier, where if you're the defense, you really have no choice. You have to continue the trial because they provided all this discovery at a late phase. And let me tell you, one thing judges do not like is when the government produces discovery late. And I'm not saying they had it and there's any misconduct, but it is a huge problem. Discovery in a criminal case is one sided. You're the government. As soon as you have it, you got to produce it. So now you're opening questions as to really when did you know? The judge is going to start digging in. And let me tell you something. We're talking about criminal cases, but I got to draw an analogy to civil cases. So in civil cases, you can't just file an amended complaint. You have to get a stipulation from the other side. There's a very short window where you can amend a complaint, even in a civil case, right? If you don't get a stipulation or agreement from the other side, you have to get leave of court. So that's essentially what's happening here, because an amended complaint, whether it's civil or criminal, can add additional charges and allegations. And it's unfair to the person who's defending that complaint to have to do so within a short period of time before trial.
So let's get to what really matters here, right? The judge's ruling. Again, Judge Michael Fitzgerald granted Durk's motion to sever. He separated counts 1 and 6 from the rest of the indictment. So that means that the Chicago killing or alleged killing and the Atlanta alleged attempted murder, that is not going to be part of the August trial. So Durk is going to go to trial on the Los Angeles murder for hire charges, just as his lawyers wanted. But I really have to get into what the judge did, because the judge didn't just, sign an order, move on, no explanation. He used this hearing to essentially put the government on blast. He told prosecutors straight to their faces that he saw exactly what they were doing. I mentioned one of the quotes before. He said he wasn't buying it. According to reporting from the Rolling Stone magazine, the judge said, quote, "This third superseding indictment indisputably is just a very clever attempt at having the Chicago tail wag the Los Angeles dog." And the judge said that it looked like the government was concerned that it was going to lose. Now, a couple things here, Neama. It's a statement for a judge to say something like that. I mean, you have never been called out like that ever before, but it's one thing. I'm curious what you think about the judge's commentary there. And I also have to wonder, are they even going to move forward with these other charges? Do you think so? Are they ever going to move forward with separate trials?
I don't think so, because you have potential venue issues, right? So you have these other alleged acts. I don't know what the nexus to the Central District of California here in Los Angeles would necessarily be in those cases. Now, obviously, they can be prosecuted in Chicago or Atlanta or elsewhere. So I think that's just one issue out the gate. Look, if they win in LA, it's probably a moot point, because...
Is it double jeopardy?
I don't necessarily think it's double jeopardy. The judge mentioned double jeopardy. I don't think it's double jeopardy. There could potentially be an issue preclusion issue depending on how granular the jurors get. Again, I was trying to wrap my head around it. There's really no jeopardy because the charges have been dismissed. Jeopardy attaches when, the jury is sworn in, the first witness testifies. So they could potentially bring those cases. But if for some reason the jurors returned a very detailed verdict that said, for instance, there's no unlawful agreement, there's no conspiracy, that could potentially be a problem in a subsequent case charging conspiracy. So again, depending on what the findings are, but usually in these cases it's guilty, not guilty, and it's impossible to know the reason for the not guilty verdict such that it would prevent the retrial in the subsequent case. So I don't think there's a jeopardy issue. The judge raised it, but which was surprising in my opinion. But I think it was mostly him wanting to blast the prosecution in this case.
Let me ask you one final point about this. So again, Lil Durk, he's now headed to trial on August 20th for the Los Angeles murder for hire case. The new charges, allegations, Chicago, Atlanta, those are severed. Maybe tried separately. We'll see. By the way, after the ruling, Durk's lead attorney, Drew Findling, released a statement saying, "We are very happy with the court's order for 21 months. We have been unwavering in our commitment to Mr. Banks and his innocence and look forward to an August 20th, 2026 trial." So before I let you go, how strong do you think the prosecution's case is against him for this alleged murder for hire?
I think it's pretty strong. Cases like this really kind of go back to that cooperator testimony. I really want to know how effective the prosecution's been to flip people. Whenever you talk about any criminal organization, it can be Lil Durk's alleged organization, mob, street gangs, cartels. You really need members of that organization to testify against those that are most responsible. Now, obviously, you don't want to rely on rats or snitches by yourself. Hopefully, you can corroborate that testimony. I know there's a lot of electronic evidence, text messages and the like here. I like that if that's the prosecution. So if you have cooperator testimony, you have that corroborated by independent evidence like text messages, I think it's a strong case. But of course, never count out Brian Steele. He did a great job in the Young Thug case. So this is going to be a heavyweight fight, Jesse.
All right. Neama Rahmani, love having you on. Love explaining it to us. Thank you so much.
Thanks, Jesse. Love being on too. Hope to be on again real soon.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. I'll see you next time, everybody.